Good morning, everyone, and welcome to another episode of the TCLF One-on-One Series. Through the One-on-One Series, we aim to interact with the best legal professionals from India and around the world. Today, we'll be talking about the world of institutional arbitration. What does the future look like? Why are more and more parties moving towards the direction of institutional arbitration? What is the council's role like, etc.? And we are honored to host Ms. Ereblinda Sadiku with us today. She currently works at the Thailand Arbitration Center and has deep insights by the virtue of her role into the world of institutional arbitration. She has the experience of studying law in Switzerland and Australia. We are truly honored to host you today, Ereblinda.
Thank you so much to the Contemporary Law Forum for inviting me today. I'm really honored and I look forward to this discussion.
Same here. Ereblinda, let's start by talking about your journey as a lawyer. What inspired you to become a lawyer at the first place?
I think that's a really good question that you should ask all the lawyers in the world. I think it was first a choice when I was a really young girl. You know, everyone was dreaming of being a doctor, a lawyer, and then I had to pick an option when I was at school. So I was like, why not picking law? And it started like this with a simple idea as a child, and it started growing more and more by watching movies. I think I was raised with these American movies on law. Unfortunately, I mean, or fortunately, I come from a civil law country, so it's really different from what I've seen in the movies. But I
Right.
started with this. That's what inspired me, I think, at the beginning, and then I think that was the beginning. But then afterwards, I started to be inspired by more concrete reasons, such as justice, fairness, and principles like these. So I think it's keep on growing. To this day, I just find new and new reasons to love being a lawyer and to practicing law. So that would be my final answer. But it depends, I think.
Right, right. I think for many people and for most people, I've heard that, law was something that they'd heard about or seen in the movies or series when they were growing up. And that is where, it essentially, drew the people
Yeah.
towards them. And I think in terms of the movies, uh, the closest that a movie comes to, real life courtroom scenario is the movie The Anatomy of a Murder. That's the closest that a movie comes to when it comes to, trial and everything. It has very, very, apt adaptations of how a courtroom trial looks like. So,
Mhm.
yeah, just a little tip for the viewers to, go and check that movie out. So,
That's
Belinda, you have the experience of studying law in Switzerland as well as in Austria. Now,
yes.
these, of course, are civil law systems, both of
Mhm.
them.
Yes.
Uh, what were the teaching methods like in these countries with respect to law? And what was your overall experience like? How do they approach the law there in terms of the study of the law?
It's a really good question because okay, there's different teaching method if it's a civil and common law system for sure. But most importantly, let's not forget that both these universities are in Europe, and Switzerland and Austria have really big similarities. What I mean is like in Europe, universities are mostly either free or really cheap. And even if you do law school, it's kind of affordable. It's you still have international private schools and that are more expensive, especially in Switzerland. We have a lot of like international private universities, really famous ones. But most of the people go to public schools because the education is good. But of course, the consequence is that you have a lot of participants, a lot of students for really only one teacher. So the consequence to this is that they have to make some sacrifices, if I may say so. In some other universities where you have less students or more selected students, you might have a more special support to specific needs to every student, or not every, but to some groups of students. Whereas if
Right.
you go to universities in Europe, you're really left alone most of the time, right? I'm excluding UK because they have a lot of private international or private universities, but usually they really leave you alone, which is a good and a bad thing, right? Because it teaches you to really learn by yourself everything. And one of the reason how it happens is that a lot of teachers actually adopt the Socratic method of teaching,
Right.
which is maybe for some of the listeners, Socratic method is just basically a discussion, a debate. There's not really a lot of theory broad, or it is maybe at the really beginning of this learning stage, but then when you keep going, there will be, okay, now we've seen this principle, what do you think it is in practice, and things like this, right?
Right.
So it is good. It's really interesting. It really forges the capacity and the skills of debate and of analytics. But
Right.
it is difficult when you arrive at the exam at the end of the year, at the end of the semester, when you actually have theoretical questions, but the only thing
Right.
you've discussed in class were principles and discussions. So I think it's a really different method, and I wish I had the chance to study in other institutions or other jurisdictions. I was supposed to study in China, but unfortunately, because of COVID, it was canceled, and I would have loved to see how what's the approach. I
Right.
believe also if you're in a common law, it's also really different because we study a lot the code, and we have a lot of interpretation because codes are really specific. You know, you have an article or disposition, and then it can
Right.
mean various things depending on the interpretation of the court. Whereas common law, you have it's a case basis. So um, I think despite having this, because you know what is actually not really known by I mean it's known by practitioners, but by students, is that even when you come to a civil law system, you actually do a lot of case study because okay, you have stare decisis, the principle that says that, like, you know, like common law systems, yeah, they have a case and the case is the decision. Sorry, the case is the principle, and that's the law and that's the source of law. But
Right.
actually, for example, in Switzerland, and I know it's the case in Thailand, and it's the case in most of the civil law systems, what the Supreme Court decides is actually also a source, but not directly written, but it is a source. So it is not really as important as common law, as the importance that common law systems give, but it is similar. So I think in terms of what we are taught, it's not that different, but the way we are taught, because we have different access to studies and to trainings, it's probably that point that is different.
Right. That was a very elaborate answer, and thank you for that. It was a very, elaborate insight into how civil law system works. And I think, you've rightly pointed out the differentiation that most people usually play out in terms of civil law and common law is, I think, too simplistic a differentiation that, common law is precedent driven, whereas civil law is statute or court driven. But that's too simplistic, as you mentioned, a view, because courts in civil law systems also decide as to what is the true interpretation of the court. But I think the most important question or the true point of differentiation lies is as to how far the courts can go. In common law systems, they go very far. They can elaborate on principles, sometimes read words into the statutes. There have been instances. Whereas
Mhm.
I don't think that's possible in civil law systems. Courts cannot go that far. They're bound by the limits of the statute. So I think this is the way to look at it. Uh, Moving on, Ereblinda, now you're currently employed at the Thailand Arbitration Center. So, what made you jump into the field of international arbitration? How were you attracted, and you decide that I want to move into international arbitration?
Mhm. It's a really good question. I was a student not so long ago, so these were kind of questions that I asked myself not so long ago on which field I should pick. I always had a lot of I was really fond of international law in general, so it was either public or private law. Public international public law is really broad, and you can work in many organizations, and you can, but as a first entry level job, it can be a bit frustrating and difficult to access.
Right.
And on the other hand, when I was studying my master's, I wanted to do international private law because I saw that there was a lot of classes about it as well, and I haven't really I only studied international private law, but I really didn't saw and followed like classes on international arbitration, and I picked one or two classes on mediation as well, and I just realized how interesting it was, and I wanted to work abroad because I believe that as an entry level position, I was as first experiences when we're so young, right? When we haven't had yet any things that asks us to stay in our home countries. I think it's interesting, at least in my opinion, right? In my own journey, it was interesting for me to decide to move abroad and to study abroad, to work abroad. So I decided I didn't have a lot of options. So international arbitration was an amazing option and really interesting. And so that's why I chose arbitration, I think, as
Right.
a really brief answer.
So it was essentially the international nature of the field that,
Mm.
was a drawing point for you. Now,
Mhm.
at an arbitral institution, most people are aware that there are councils, there are, in-house people working at an arbitral institution, but they're not actually aware of the day-to-day responsibilities. So in your work profile, what does an average day look like? What does your work profile involve? And what are the challenges like that you face?
I think first, let me say that it's really different depending on the country. I've been working here in Thailand. It's even different depending on the institution within the country. So when you're in a really established institution, for some of the students might have heard of, such as the Singaporean one or the Hong Kong one or Swiss one, Paris one, or London one. These are really established one, and the hierarchy are really well established. Your responsibilities are really well decided and well organized. In
Yes,
these scenarios, councils are kind of the same everywhere. You're going to be basically a contact point for between the client slash the council if they have one, the legal lawyer. So
right,
between these the parties and the arbitrator,
right,
and so this is broadly, but then more specifically, I will only talk about Thailand Arbitration Center because we are
right.
different than some other ones. We have more responsibilities because we are kind of a newer, of course it's not that new, but when you compare the other institutions, we are one of the newest. We're kind of new institution, so we have a lot of responsibility for a council. So for specifically, which is not required from other institutions, we review the awards, for example. So for some of the
Right.
students, the award is the decision that the arbitrators give. So we review the awards of the arbitrators. Of course, we are not going to refuse it, but usually we just help them. Maybe there's typos, or and usually also the content. Sometimes they ask us to review to be sure that they respected correctly the rules, the Thai law, or whatever law they decided to apply. And
Right.
on another level, because we're so new, we also have to promote ourselves a lot in other
Right.
institutions, and this one differs with every other institutions that you will have in the region at least. Councils really focus on case management, so which means that they will welcome the clients, they will explain the rules, they will help them file the case and close the
Right.
case, pay the fees. In THAC, you will have more of a promoting uh, how to say, like, you have to yes, you have to go outside, you have to go to events, you have to create
It's
trainings, you have
also
to.
about business development.
Yes. So
Right.
you do a lot of business development despite being a lawyer. And it's
Right.
really interesting because you network a lot. And basically, arbitration, in the opposite of every other field that you have in law, is
Right.
really network. You have a lot of collaboration and a lot of cooperation. In other law fields, I would say there's more competition. In arbitration, people really help out each other because even if maybe you are, as a lawyer, you're not going to get the case directly, if you help
Yes.
raise awareness in the country, it will bring cases and you will at some point have clients and more clients. And for institutions, it's the same, right? Maybe Thailand is smaller than Singapore, but if we keep helping each other, there's going to be more cases in Thailand. And at some point, we're going to be happy as well. So
Right.
I would say these were the responsibilities and the challenges. I would say that
Right.
as an institution, you have a lot of responsibility in THAC. In other institutions, you have less a little bit. And the councils, you just have to be really professional and ethical and really,
Right.
really detail oriented. I mean, a lawyer in
Right.
general has to be a detail oriented person, but you have to be sure that you don't make any mistakes in when you review the award, when you the date, the deadlines are really, really important. I mean, for every lawyer, but as a counsel, you have to be sure that they're respected. So these
Right.
are, yes.
So, as I understand the role, your particular role, especially at the Thailand Arbitration Center, it being a slightly newer arbitral institution, is everything from case management to helping out the parties, with their filings, with the closing of the case, with the payment of the tribunal, uh, payment of the fees for the tribunal. So all these case management tasks, as well as, post-award review works, and also business development strategies in order to promote the arbitral institution, so that it can be a hub for the resolution of disputes. As I understand, these are the broad areas that a council is supposed to work on.
Exactly.
Now,
As an
Ereblinda,
example, I'm sorry. As an
yes, yes,
example, I have been assigned when I started this position, I have been assigned to launch an academy, which is really not technically something that a lawyer is supposed to do, but I have a really good understanding of what students are looking for. So
right.
we create curricula. So yes, that's just an example.
That's great. Now, Ereblinda, as you've rightly pointed out, uh, arbitral institutions alongside, as you've said, it's a big community, the arbitration community, where everyone's helping out each other. These institutions are playing a greater role. We we were witness to this, especially during the time of, the pandemic, wherein arbitral institutions were the first institutions, I think one of the first institutions, uh, arguably, who launched new rules so as to accommodate, you know, the difficulties that have arisen on account of the pandemic. Virtual hearings were becoming robust. The
Hmm.
facilitation with the tribunal was, made smoother so that parties can appear virtually. Even the evidence can be led virtually. All of these things were made, work. They were being worked on, and new rules were being launched by most of the centers.
Mhm.
Now, as you can see, Ereblinda, more and more parties are moving towards arbitral institutions. They're preferring it over ad hoc arbitrations. What what is the reason behind that trend, and what does the future look like for institutional arbitration?
I think as I was just, we can link this with what I was just saying that when you go to an institution, you have a lot of structure and support from a
Right.
secretariat. And I think that's why we are so famous, or more, not famous, but successful, more successful than ad hoc arbitration, for example.
Right.
But also why the second thing is as well is that we can promote ourselves, right? We have an image, we have a brand, you have a face you can put on where to go when you have a dispute and you want to resolve it. Whereas if you want to contact a specific lawyer that will help you have, or not necessarily a lawyer, by the way, but most of the time a lawyer that you want to help him or her resolve your dispute as an ad hoc arbitrator, well, you still have to make a lot of research because you have to find a person that is competent and
Right.
expert in your field. Whereas if you go to the institution, you will ask the institution will take care of contacting the arbitrators that are impaneled in their panel, and this will have an impact on for example the expertise of your arbitrator, because we have a list of the department, the fields that they are experts on in, and we will just select them. And you, of course, arbitration is really you always have to ask the consent to the parties, except if it's written in the
Right.
rules. It's kind of rare. So
Right.
as long as it's consensual, we usually just appoint a really expert one, and the parties are really happy with it. They can always
Right.
challenge the arbitrator. So um, this, and also they don't have surprises on fees, for example, because
Right.
it's written in the rules. So if you want to know how much it is, you go to the website of the institution. All the institutions have a so-called fee calculator. You put the
Right.
amount in dispute, and it will be written how much you're going to pay at the end. Of course, you have a lawyer. Most of the time, people have legal counsels or lawyer on the side to help them deal with the case. So that we cannot know how much you're going to pay a lawyer. But
Right.
this will also be a cost that you will have in front of an ad hoc arbitration. So at least the fees that you will pay the arbitrator is fixed, and the deadlines are also really because arbitration, we want to be fast.
Right.
You have like a specific amount, and you know the deadline, and no one, and the secretary and the arbitrator has to respect it. But
Right.
all these points that I've said are also really disadvantages for some parties, right? Like you have to know that every party has different needs. Some people want to have more liberty, more freedom when they choose fees and when they choose deadlines. Maybe sometimes some
Right.
people don't want to have it fast, they want to have it in a longer period. It's up to everyone, right? But at least the structure is really, I think that's why we are so successful. The institution arbitration is becoming so successful.
Right. I think also another factor that that needs to be looked at is that for domestic disputes, or from what I've witnessed, is that ad hoc arbitrations are more popular because, domestically, especially talking about India, we know the kind, what judges or which arbitrators are popular within that field and have resolved disputes. So they are the, go-to choice. And
Yeah,
domestically, they're just more comfortable seeing familiar faces who, they've seen maybe in court, maybe who know, that, or the parties know them that, that he's a good arbitrator, etc., etc. But I think
true.
with international disputes, especially international commercial arbitrations, institutions are more, popular because you need that structure in place. Both parties have the trust, not within a specific person, but to that institution, seeing their
Mm.
record. And, these institutions are famous for resolving, these international commercial disputes. So I think for international arbitration, especially, these institutions become the go-to place for the need of that structure and, for the need of that arbitrator who specializes within those, particular areas of law. So I think that's an important point as well. Now,
It is.
Arabinda, moving to the last segment of our conversation, from your journey and from your experience at an arbitral institution, what is your advice to, law students as well as young lawyers who wish to get employed or who wish to work with these arbitral institutions as counsels? What are the relevant skill sets that they should develop, and, how should they go about it?
Good question. Really good question. I think if I look at my own experience, I was a clerk in tribunals in Switzerland. So I already had these drafting skills, if I may say so. In an institution, you will not draft, but you have to have good drafting skills to be able to have good correcting skills. So
Right.
I was responsible of drafting decisions for courts in Switzerland. So this helped me a lot. So if you can have this kind of experience, either as maybe a clerk in a court, if it's possible. I don't know how is the system in India or in any other country,
Right.
or if you can work in academically where you have to draft a lot of articles or things like this. It will help you first really a lot on distinguishing the details that you should focus on when you are going to read an award and things like this. And then I think a lot of social skills are required, but this is not really something you can study. It's just that you have to be someone really understanding. You have to know that you're going to be under the parties are the priority,
Right.
but you have to be sure that both the parties are your priority, not only the claimant, despite the claimant being the party that usually brings the case to the institution. So you just have to be sure that you're fair as well, because there's
Right.
a lot of problem related to that. But now more in terms of skills or trainings that they should follow. I myself followed specific arbitration classes, and if I may give you an opinion or an advice on more what is the future like, or what I have accounted recently, I would say that the future is mediation. Arbitration is
Right.
already really present and has been for
Right.
the last 20, 25, 30 years, even more for some countries. But
Right.
mediation is beyond important and is gonna be replacing arbitration for sure. For one, and I mean for many, many reasons. One of the reasons is also because you don't really need to be a lawyer to be a mediator. You just need to have good social skills and have a lot of emotional intelligence. And
Right.
so I would say if they're interested in having in working in a field that is the future, mediation is also a really interesting field.
Right.
As a counsel, more specifically, if you really wish to only be a counsel as a secretariat member in an institution, I believe that law studies are really enough. And if you can add up some clerk experience, it's amazing.
Right.
Then if you wish to know as a lawyer in which specific area you should work on, I would recommend to go through mediation and arbitration as well. But mediation is really big. I myself followed some trainings recently. I'm now an accredited mediator, so
Right.
it's important, I think, to know also what's the future. It's now law is becoming so expensive, so
Right.
mediation is a good opportunity for your parties, for your clients, because it's cheaper,
Right.
faster. So it's good. And I think in Asian cultures where you have a lot of um pacifism, or people try to be really um, dispute friendly, or I don't really know how to phrase this. It's a really good
Yeah.
point.
Right. these are some great takeaways, Ereblinda, and I'm sure that these would help the viewers out there, and they should really focus upon these uh, suggestions if they wish to go into the field of alternative dispute resolution in general, as to what the future is like, as you rightly pointed out. And with this, we come to an end of our conversation. Thank you so much again for joining us today. It was really insightful, and I had great fun just having this conversation. Thank you so much.
Likewise, and thank you to the TCLF for inviting me. It was really appreciated. Thank you so much. And as a last comment, if any of your subscribers or students that are following your forum are interested in contacting us or me, please feel free to. I mean, we have to help each other to become bigger, right? So thank you so
Absolutely.
much again.
Thank you. Thank you, everyone.
Thank you, Shashwat.